I think during the morning recess, Ms. Coates and my judicial assistant, who's named Ann Wood, will be meeting with you back in the jury room and talking with you further about restaurants. I'll mention this to you again. Please feel free to bring cell phones with you, but keep your cell phones turned off if you have them here in the courtroom. You're certainly free to make phone calls during the recesses and over lunch. Feel free to bring bottled water in with you to the courtroom, cough drops if you need those, but otherwise please no eating or drinking in the courtroom. Again, you're certainly free to get snacks and so forth over the recess. All right, I think that's it regarding housekeeping. Madam Jury, we want to impanel the jury. Members of the jury, if you would, please stand. Let's impanel the jury.
Ladies and gentlemen of the jury, you have been sworn and now impaneled to try the case entitled The State of North Carolina versus Jonathan Douglas Richardson. You will sit together, hear the evidence, and render your verdict accordingly.
You may be seated. Members of the jury, the defendant in this case stands charged with the offenses of first-degree murder, felony child abuse inflicting serious bodily injury, sex offense with a child, and first-degree kidnapping. To all of those offenses, the defendant has entered pleas of not guilty. And I would remind you again that the defendant is presumed to be not guilty of all of those crimes. The burden of proof in this case will lie entirely on the prosecution to prove his guilt of any crime charged beyond a reasonable doubt, if the state is able to do that. And that phrase, by the way, beyond a reasonable doubt, has a specific legal meaning, and I will discuss it with you later in the trial. I remind you of these offenses because when the first two or three of you were seated, I told you that the defendant also was charged with rape of a child. He does not stand charged with that crime. He stands charged only with the four offenses I just reviewed with you. Now I want to take just a moment and explain to you the procedures we'll be following in this case. The first thing that will take place will be the opening statements of the lawyers. Now, please understand that the opening statements of the lawyers are not evidence. Witnesses will be called to the stand, placed under oath or affirmation, questioned, perhaps cross-examined by the attorneys. Evidence may also come in the form of exhibits, such as, for example, photographs or documents or physical objects. If at some point a lawyer asks to publish an exhibit to the jury, it may be that the exhibit is literally passed around amongst you. If that occurs, please examine each exhibit that is published to you carefully, individually, and without comment. Question you should disregard and not consider during your deliberations the evidence that has been stricken. Now, during the course of the trial, it is quite likely that questions of law will arise that need to be considered by the court outside of your presence. If that happens, I may ask you to go to the jury room for a few minutes. To the extent possible, I will address such questions of law around an opening, around a recess or around the lunch break or at the end of the day after you have left, so as not to interrupt the flow of testimony. But sometimes it's simply unavoidable. I will need to ask you to go back to the jury room just for a few minutes while I take up the issue. Please do not worry or speculate about what is taking place in the courtroom during your absence. We will merely be considering questions of law that I am required to hear outside of your presence. I can assure you that all of the competent and admissible evidence will be presented to you while you are present in the courtroom. Now, when all the evidence in the case is completed, the lawyers will have the opportunity to make their final statements or arguments to you. And then finally, I will give you instructions as to the law that you will apply to the evidence as you go back to the jury room and deliberate upon your verdicts. Now, there are some rules that will govern your conduct throughout this trial. I think all of you have heard most, if not all, of these rules during the jury selection process. I'm going to review them with you in full at this time, and I will remind you of these rules, at least in some summary fashion, before each and every break. But they are extremely important. First, you must not talk about this case among yourselves. The only time and place you may talk about this case will be in the jury room after I tell you to begin your deliberations. Next, you must not talk about this case with anybody else. That does include members of your households. Please don't allow anybody to talk with you or to say anything in your presence about this case. If anybody attempts to do that, please report that to me through one of your bailiffs right away. By the way, when I say don't talk about the case, as I think I told all of you down in Harnett County during jury selection, I do specifically mean you don't post anything about it on Facebook or tweet about it or instant message about it or anything of that sort. Please keep your cell phones turned off while you are in the courtroom. Please keep your minds open. Refrain from forming or expressing opinions about the case. Keep your minds open until you've heard all the evidence in the case, the final arguments of the lawyers, and my instructions to you as to the law. Next, please don't have any communication of any sort with the people involved in this case. That obviously and expressly means the lawyers, any of the state's witnesses, anybody associated with the defendant or any of the defense witnesses. If you were to bump into these folks in the atrium or into one of the hallways, please don't even say good morning to them. I'm sure you understand. We want to avoid not only any impropriety, we want to avoid even the appearance of any impropriety. Next, please avoid any press coverage of this case. There has been, and there is going to be press coverage of this trial. I can tell you, for example, that channels 5, 11, and 17 have communicated with the court concerning press coverage. I'm not going to bar you from watching the news on television, but you must absolutely avoid any coverage of this trial. That also means, of course, that if you were to visit one of the websites of these television stations or of any newspaper station, or newspaper that may be covering the trial, and I will try to alert you to those as I become aware of them. Don't read any story online about this trial. Do not attempt to conduct any sort of investigation on your own to this matter, either into the facts or into the law. As I've told you in the past, I will give you the law that you need to know at the appropriate time throughout the trials. Please obey these rules to the letter. Please understand that they are an order of the court. And if you violate one of these rules, you are violating an order of the court. You can find yourself subject to a finding that you are in contempt of court. And we never want that to happen to one of our jurors. You folks are the most important people in this trial. We will do everything we can to accommodate your needs. You did meet the transportation officers. Just a brief word of introduction to other people involved. I would remind you of the lawyers, Mr. Butler, Mr. Jackson, Mr. Brown, Mr. Clinton, on behalf of the defendant. You met your transportation officers. As I said, your bailiffs on a day-to-day basis here in the trial will be Mr. Bob Crocker, my left, Mr. Marshall Tucker, to my right, our courtroom clerk, who you met down in Harnett County, Ms. Jamie Coates. This is a court of record, as you understand. Everything that's said or done in this court is taken down by a court reporter. Our court reporter at most times during the trial will be Ms. Tina McNair, seated directly in front of the bench. I will introduce other people to you as everything's necessary throughout the trial. Now, I've also been told that there's been a request from one or two of you concerning note-taking. I've discussed that with the lawyers, and in my discretion, you will be allowed to take notes. I'm going to pass out at this time, or have the bailiff pass out to you notepads and pens for your use. As soon as he's done that, I'll have some instructions for you concerning note-taking. All right, Sheriff? Portions of the testimony. Moreover, any notes taken by you are not to be considered evidence in the case. Your notes are not an official transcript of the trial. For that reason, you must remember that in your jury deliberations, notes are not entitled to any greater weight than the individual recollections of other jurors. If you decide to take notes, you may disclose them only to your fellow jurors, and only during your deliberations. You are not to show them to anyone else. While I will permit you to take notes, I do instruct you to listen intently at all times to the testimony. We notice, of course, that the bailiff passed out to you, along with the notepads and pens, manila envelopes bearing your juror number. During each lunch, recess, or at the end of each day, please just simply place your notepads inside the envelopes. Leave them flat in your seats as you leave. They will be collected at the end of each day by the bailiff and deposited with our clerk. She will keep them in a secure place overnight and pass them out to you the next morning. She will not look at them. She will not disclose them to anyone else. These notes are for your use only. At the end of the trial, after verdicts are returned, the notes will be collected. They will be destroyed. One other thing I meant to mention regarding press coverage, I do want to assure you that under the rules of court, the press is not allowed to photograph, film, or videotape any juror. So your images will not be recorded, and of course the press is not allowed to contact you at all during the trial. All right, I think we are now ready for opening statements. For your information, I will take a recess between the opening statements. There will be an opening statement for the prosecution.
Yes, sir.
All right, you're going to use this equipment, is that correct? All right, put it in place, let me know when you're ready.
No, Your Honor, I do not. I may have a moment.
Yes, sir.
back to the jury in just one moment. With the vice president, I'll finish this.
I just have to swap it.
All right, outside the presence of the jury, there's a trouble with this technology. That always happens.
Well, every time that I have to set the PowerPoint up, it has to be, I have to swap the screens, and that's what I would do. I would have to do. Just take 1 second to do that. You should be able to see it once
We'll be at ease just one moment. If anybody needs a 60-second break, feel free.
you should be seeing it on your screen, Ron.
I've got a tiny image of a girl in the upper right-hand corner.
Right, that is the PowerPoint display. That is not what they see. What